they don't have them there yet. So and then we'll go on the record in this Frymark's case. This is People versus Frymark, case number 244989. The record should reflect Ms. Frymark is present here in the courtroom today. If I can have counsel put their appearances on.
Brian Ziegler,
Thomas Seeger on behalf of Ms. Frymark.
All right, thank you. This is set today for a status conference, and Seeger, your motion to dismiss. I did have a chance to review your motion and brief. I also had a chance to review the preliminary exam transcript. State for oral argument support of the motion.
Yeah, I would just generally rely on the brief that was submitted. If the court has some kind of question one way or another, I can try and answer it.
Thank you, Mr. Ziegler.
Your Honor, I just want to, defense had filed a response saying that People versus Core wasn't applicable. I just wanted to spend a moment addressing that. I think People versus Core is directly on point here. In that case, you had someone who was not the subject of the police interest. They were not a suspect. They were not arrested. And they attempted to leave the scene, and police exercised control over that scene. The defense's arguments to the contrary tried to distinguish this case by saying she was at her own home, or by saying that the animal in question belonged to the defendant. But the principle of maintaining control over a scene really applies to any criminal investigation or any place where law enforcement are there lawfully performing their duties. It's not a question of this should only apply at traffic stops, or this should only apply when a driver is detained. It's a question of officer safety and maintaining safety at a scene where law enforcement is performing their duties. So for those reasons, Your Honor, I would just ask the court to follow the precedent of People versus Core, and in all other respects, I rely on my written briefing unless the court has any questions.
And Your Honor, the only thing that I would add is that to the extent that we're talking about them maintaining their scenes, there was some precursory work that other officers were allegedly doing. I would note that none of them are complaining witnesses in this particular case, that it only relates to one particular officer, i.e. the officer that was allegedly bitten by the dog. So to that end, Your Honor, that officer's duties have been completed. So as far as I can tell, if there was a lawful command, which I'm not conceding, but if there was a lawful command, that command had ended by virtue of him being done with this investigation. But if there were other officers on the scene that were doing paperwork or something of that nature, and that somehow is encompassed within Core, which again, I think is distinguishable because again, that was a traffic stop, and that really has to do with proximity, or at least that would be my belief that it's more related to proximity, wherein Ms. Frymark was at the top of the hill next to her house, and Mr. Delbosque, the suspect, was found, I don't know, way down the way, such that they had to use a search dog to find Mr. Delbosque. They were nowhere near each other in terms of proximity, which is, I think, the intellectual underpinnings of a traffic stop, wherein there are two people in a vehicle and you don't know the other person and you stop the vehicle. There are different exceptions for traffic stops, and also based on the proximity, I think that those are factually and legally distinguishable. But be that as it may, Your Honor, I don't think that Core applies. Additionally, I think that the case should be dismissed because the quote unquote lawful order was over at least after they had secured Mr. Delbosque, which is exactly what happened in this case.
Okay. All right. So again, I had a chance to review the briefs. I read the preliminary exam transcripts. I'm familiar with the facts, at least as they were testified to at that time. First of all, this case has been bound over, so this is really a review of the district court's bind over. I think there are mixed questions of law and fact here. The court is to review rulings of law under a de novo standard, and findings of fact under an abuse of discretion standard in terms of the bind over and whether this case should proceed to trial. From a legal standpoint, I did read People versus Core. I think there are arguments both ways as to whether that's really on point and applicable in this case. I think what it really comes down to is the statute involving resisting or obstructing, which allows for circumstances where police have given a lawful command circumstances where they were making a lawful arrest or where they were otherwise performing lawful acts. So it's a pretty broad set of circumstances. And clearly in this circumstance, they were involved in making a lawful arrest, although not of this defendant. And they were there performing a lawful act. They were responding to a complaint for domestic violence. And so to me, it doesn't turn on whether there was specifically a command to restrain the dogs or not. The police were there on the property performing lawful acts. So I think it generally comes within the scope of the statute. And so from a legal standpoint, I don't find that there's a legal reason to dismiss. And so then therefore, is there sufficient factual basis under abuse of discretion standard? The district court clearly found that there was sufficient facts for to substantiate probable cause for the case to be found over. And I think this is one of those cases that the prosecutor has discretion in deciding what to charge and what not to charge. That's not up to the courts. Prosecutor has decided to exercise that discretion. Looking at the elements, it includes where a defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered. And I think that's really the applicable portion of the statute here. And I think there is sufficient evidence based on the testimony of the police officers and the circumstances that the actions of Ms. Freimark arguably endangered those officers in her failing to restrain the animals and did result in some injury. So under an abuse of discretion standard, which is a very low standard, the court finds there is sufficient evidence for the case to go to trial. Now, I mean, Mr. Seeger, I think you make a really good argument from a factual standpoint. I'm not sure if I was on a jury that I would convict Ms. Freimark under these circumstances, but I'm not the one who's going to be making that decision. And I think this is the exact kind of case that, to the extent the prosecutor's charging it, to have a jury of our fellow citizens here in Kalkaska decide whether this is conduct that should be considered endangering police officers or not, and let the community decide where we're going to draw that line. And I think this is one of those cases where a jury very well could side with the defense and say, we don't think that this is criminal conduct. They could side with the prosecutor. But again, I think this is the classic case. The reason why these are not cases in our system of justice are not decided by a judge or by lawyers, they're decided by a person's fellow citizens. And I think there's a sufficient factual basis to have 12 of our fellow citizens make that decision in this case. So the court's going to deny the motion to dismiss. In terms of proceeding, do we have a trial? Yeah. Have we set this for trial yet?
Your Honor, it was set for April, I want to say 23rd, and then we had filed a stipulation to move it. I'm not certain if the court has signed that. I thought it did, but I'm not seeing a copy of my file.
I have a note. It looks like it's probably from China.
I did have to notice on the docket, it said that the trial, or at least I believe I saw that it said that on April 23rd that we're proceeding to trial, but I did sign a stipulated order with Mr. Ziegler with the permission of my client, stipulating to the adjournment to the extent that the court is willing to adjourn it, but I take no position. But
did that happen last week?
I don't remember when we signed it, Aaron. I just remember that we had.
Your Honor, it was signed on March 10th and forwarded to your assistant.
Okay.
I want to say I got an email copy back, but I don't have it in my file.
Did your stipulation include a new trial date? Or
It did not.
Okay. All right, so Mr. Ziegler, is there any particular period of time that you need to be ready to go to trial?
Your Honor, just the basis for the stipulation was that Antrim Deputy Skylar Skrabecki, who was the K-9 officer, is out of state from the 17th to the 27th. So I don't need any more time beyond April 27th.
Okay. Mr. Seeger?
Your Honor, I'm generally prepared to go to trial. I just need a date certain to the extent that if I need to subpoena anyone, that I can get those out in a timely fashion. I assume the same is true, Mr. Ziegler.
Okay, and did we have this set for a 1 day retrial or 2?
Looks like.
Yes, Your Honor.
1, okay. All right, so we'll set it for a 1 day jury trial at the court's next available date. It won't be prior to April 27th. So the court will send out notice of the date and time of that trial date. Mr. Seeger, did you want to request a final status conference prior to the trial?
Your Honor, I don't think one final status conference would be hurtful. So to the extent that the court is willing to schedule that, that's fine.
Any objection?
No, Your
to
Honor.
that? Thank you, Mr. Seeger. Anything further from your side today?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
Thank you. That's all on this file today.
You're good about it.
People versus Hauser, case number 255032 and 5032. Mr. Hauser's present here in court today. I can have counsel put your appearances on this.
Ziegler on behalf of the people, Your Honor.
Thomas Seeger, on behalf of Mr. Hauser.
Can you tell me how we're going to proceed in these files, Mr. Seeger?
Your Honor, Mr. Ziegler and I continue to be in discussions about a potential resolution, and it's probably likely that the matter will resolve itself. However, Your Honor, I would ask the court for an additional period of time so that we can continue to try and work out some details one way or another. And if we're unable to, Your Honor, I guess we can just have a trial. The guidelines are not significantly different the way that they're scored. So if he had a trial and he lost miserably, which I'm not saying he will, even assuming everyone really did, they're not significantly different from that, which is the plea. And so some additional time might be helpful in terms of potentially resolving the file. That's not to say that Mr. Ziegler's position will change in any way, but it will at least give us some additional time to try and work out some small particulars if that's possible.
Okay, any objection to that, Mr. Ziegler?
No, Your Honor.
Looking at the charges here, I think it's reasonable to allow a little bit of additional time. So the court will set this for a plea hearing status conference in 30 days. At that time, if we don't have a plea agreement, then the court will set it for trial. So Mr. Hauser, between now and then, you need to talk to Mr. Seeger. And at our next hearing in about a month, I'll need you to be ready with a decision as to whether you want to enter into any type of plea agreement or go to trial, okay?
Yes, sir.
And whatever you decide on that date will be final. Mr. Seeger, anything further?
No, Your Honor.
Mr. Ziegler,
No, Your Honor.
do you have any questions, Mr. Hauser?
No, sir.
Okay, thank you. That's all for today. Sir, are you Mr. Goodrich?
Yes, I am.
Okay, thank you. We'll go on the record in People versus Jeffrey Goodrich. This is file number 255023. The record should reflect that Mr. Goodrich is present today by video from Bella County Jail. Mr. Seeger, how did we want to proceed in this file today?
Your Honor, due to Mr. Goodrich's incarceration in Isabella, I've been unable to speak with him. I was wondering if I could have a small breakout room with him briefly just to discuss what we may or may not wish to do with this file.
Yes, definitely. So Mr. Goodrich, I'm going to put you into a breakout room with Mr. Seeger, your attorney, so that you can have a confidential discussion with him, okay?
Okay, thank you, Your Honor.
Your Honor, this isn't helpful, but do you have the Zoom code to save items clear result?
Okay. Never actually enter it. So.
Exactly. Yep. Just give me one second.
Mr. Goodrich, it's just going to be a minute because we need to have your attorney sign in to Zoom.
Your Honor, maybe while waiting, and that's my error that I don't have a Zoom code, but Mr. Patrick is here. We could take his file.
Okay, sure, that sounds good. So just hold on for a minute, Mr. Goodrich. Mr. Patrick, if you want to come forward, please. Mr. Patrick. This is People versus Darnell Patrick, file number 244981. The record should reflect that Mr. Patrick is present here in the courtroom today. Mr. Seeger, how did we want to proceed on this file?
Your Honor, it's my understanding that people have offered Mr. Patrick an opportunity to plead to an OWI second. In exchange, the OWI third would be dismissed.
Okay, is that a correct statement of the plea offer, Mr. Ziegler?
It is, Your Honor.
Mr. Patrick, have you had a chance to talk to Mr. Seeger about this plea agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Lower your hand. Mr. Patrick, are you currently on any kind of probation or parole?
Oh, that's right.
And you understand that the maximum possible penalty you could face for operating while intoxicated as a second offense is up to 1 year in jail. With that maximum possible penalty in mind, what is your plea to that charge today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and do not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all of those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Has anybody threatened you with anything to get you to plead guilty?
Yes, sir.
Has anyone promised you anything other than what we said here today in court? Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are in fact guilty of this charge?
Yes.
Okay, so what was the date that this incident occurred on? Do you remember?
October 12th of 2024.
Does that sound right date? Back on October 12th of 2024, had you been consuming some alcohol? The charge is that you were operating with a high blood alcohol content. So you weren't consuming alcohol in that?
Oh, no, not yet. Yes.
Okay. And after you consumed alcohol on that day, did you operate a motor vehicle on Rapid City Road here in Kalkaska County?
Yes.
And did you have any kind of blood or breath test to determine the level of alcohol in your system? Do you remember what that showed?
0.33.
Okay. Do you have any reason to doubt the accuracy of that test? Okay. Had you consumed enough alcohol on that day that your ability to safely and normally operate that vehicle, that you weren't able to do that? Had you previously been convicted of operating while intoxicated back in 2016 in Elkhart, Indiana? Okay. Mr. Ziegler, are the people satisfied with the factual basis?
Your Honor, if I could ask the court to take the factual basis as to the second prior as well, just because the one is outside the 7 years.
Sure. So I see here, Mr. Patrick, that you were convicted on October 14th, 2015 in Elkhart County, Indiana, and on August 20th of 2016, also in Elkhart. Is that correct?
I'm satisfied with the factual basis, Your Honor.
All right, Mr. Seeger.
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Patrick, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. In the meantime, I'm going to have you meet with the probation department for a pre-sentence report. And Mr. Barrett or Ms. Wagner, how do you want Mr. Patrick, how do you want that contact to occur?
He can just come over to the office, please.
Okay, so after this hearing, I just
Thank
need
you.
you to walk across the little way there to the next building and.
To the glass,
What's that?
the glass window right there, or the next building?
No, the next building over,
Okay.
just across the walkway there, and then go to the probation department. There'll be signs directly. And then before sentencing, make sure that you stay in touch with Mr. Seeger, okay?
Thank you.
All right, thank you.
Thank you. And your arm, I'm gonna connect with Mr. Goodrich.
Okay. Okay, Mr. Goodrich, I'm gonna put you into that breakout room with Mr. Seeger now.
All right, thank you, Your Honor.
While we're rating, did you and Mr. Seeger say Mr. Lancer was lodged somewhere?
He's not lodged, Your Honor. He was admitted to TRICAPS, which I think is some kind of substance abuse recovery program.
Okay,
And so we didn't prepare a writ because he wasn't in law enforcement custody.
okay,
I don't know if Mr. Seeger or the facility made other arrangements to have him here.
okay.
Good times.
And the internet. I'm bringing Mr. Goodrich back in, but there's a little lag here, so it'll be a second.
While we're waiting, it wasn't on my docket, but the clerk had sent me a note saying that Mr. Inman is going to be seen at 11, but it's just not on the docket, so I just want to make sure that it's still an event.
Mr. Who?
Inman,
Inman.
I just gotten a note from Jennifer about it. I was just making sure, because it wasn't on the docket that she had sent, but she had sent me an email.
Yeah, I think
saying
she
it's
sent
gonna
an
be added.
email.
Yeah, I do see
Yesterday.
that on here.
Okay,
Yeah.
is that for the probation violation or is that an arraignment?
Assuming that's a probation violation.
Okay,
It's the 23 file.
okay, that's fine.
Okay, we have Mr. Goodrich back. Mr. Seeger, did you have an opportunity to speak with him in the breakout room?
I did, Your Honor.
Okay. How do we want to proceed today?
Your Honor, he would ask the court to consider giving us an adjournment, primarily because we've not had a lot of opportunity to discuss it. I have previously gone to the Antrim County Jail when he was lodged there, but then he was released, and then subsequently after he had been released and picked up and taken to Ingham County, I've not been able to coordinate with him primarily because I didn't know where he was. In any event, Your Honor, if the court will give us an additional 30 or 45 days or something of that nature, I'll at least be able to discuss with them what he may or not, what he may or may not wish to do with this file.
Okay, Mr. Ziegler, has there been a plea offer in this case?
There was an offer made, Your Honor. The current offer is to plead to count 1, which is the fleeing and eluding 4th degree, the habitual 3rd, and count 2 be dismissed.
Are you anticipating any changes to that or new or different plea offers?
I'm not.
Okay, so Mr. Goodrich, I'm going to set this for another hearing in about 30 days. That'll be a plea cutoff hearing. So between now and then, I'll need you to speak with Mr. Seeger, consider that plea offer, and at our next hearing, I'll need you to be ready with a decision as to whether or not you want to accept that offer or go forward with trial, okay?
Okay, thank you, Your Honor.
Do you anticipate that you're still going to be lodged in Isabella County?
No,
In
I'll
about a
be
month?
getting, no, I'll be getting out today or tomorrow.
Okay. Mr. Seeger, do you have good contact information for Mr. Goodrich?
Your Honor, he did provide me with a phone number this morning, which is different than the number that I had previously saved for him. But I did direct him to call me. He didn't have a writing utensil, but I did direct him to, at a minimum, if he's unable to locate the number, to call the district court here, which will be able to provide information.
Okay, so once you're released, Mr. Goodrich, you need to get in contact with your attorney as quickly as possible.
Right.
And then I want to make sure that we have a good address, because we're going to send you a notice of the date and time of that hearing. Is address on Division Street in Bel Air, is that still a good address?
Yeah,
Okay, so we're going to send that notice to that address. If your address changes, you need to notify the court of that, okay?
okay, I will.
And and we'll go forward at that time. Do you have any questions, Mr. Goodrich?
Not at this time, Your Honor.
Okay, Mr. Ziegler, anything further on this file?
No, Your Honor.
Mr. Seeger? All right, Mr. Goodrich, that's all for today. We're going to go ahead and disconnect at this time.
Okay, thank you.
People versus Lancer, this is file number 244996. This was set for hearing at 9:15. It's now 9:30. Mr. Lancer has not attempted to connect by Zoom.
And Your Honor, he is in rehab at Breakout, so I'm not sure if they made it possible for him to appear.
How did you want to proceed?
Your Honor, I don't particularly need Mr. Lancer to be present for the motion, and I can let him know what happens with the motion one way or another, so I think we could do it in absentia.
All right, my view generally, I mean, what I don't want to have happen is to create some type of reviewable issue if the court were to rule against Mr. Lancer on this, given that it's a dispositive motion to dismiss. So I would prefer not to have the hearing until Mr. Lancer is present, just to avoid any type of argument later that his lack of presence somehow resulted in prejudice to him if there is a conviction eventually. So I'm gonna put this back on the docket for May. And I don't think it seems like 15 minutes is the normal docket slot is enough time.
That's plenty of time.
Was there a prelim run in this case?
There was not, Your Honor, we did waive the preliminary examination.
Okay. Mr. Ziegler, do you have any objection to that way of going forward?
No, Your Honor.
So we'll put this on the docket for May. If you can, Seeger, if he's still in tri-cap, let him know that if he's not present at that point, I'm gonna give him one more opportunity. If he's not present, I'm gonna consider that he's waiving his presence,
It's fine.
and we'll go forward with the motion.
Your Honor, do you need me to create, and I take no position, but do you need me to create a new notice? Because ordinarily I would create it.
Yes, please.
I'll just coordinate it with the clerk and figure it out.
Yeah, there should be room.
Okay, that's
in the
fine.
docket.
Hey, Terry, do you know if we brought Mr. Inman over? Actually, there is, I'll just look.
Our next hearing set for 9:45, so we'll take a short recess until that time. We're on the record in People versus Christina Petty. This is file number 25-5005. The record should reflect Ms. Petty's present here in the courtroom today. If I can have counsel put your appearances on.
Ryan Ziegler on behalf of people, Your Honor.
Kyle Travis on behalf of Ms. Petty.
This is the date and time set for a sentencing hearing in this matter. Ms. Petty, did you have a chance to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, I did.
Mr. Travis, are there any additions, deletions, or corrections?
None that I'm aware of, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections? Anything on behalf of the people for allocution?
Your Honor, I think the report does a good job of laying out the background. Conviction. They were all relatively close in time, and although I don't know if the report, they were all relatively high EACs as well. In particular, this offense, she was on probation to the district court, and probation, she completed her first probation, her second probation was not going so well, and at some point during that probation, she committed the instant offense. I think given her track record of continually using alcohol, particularly while on probation, another term of probation is unlikely to deter future criminal behavior. I think the recommendation for jail term is appropriate in this matter. I think we've given her a couple opportunities on probation, and she's demonstrated that's not going to be effective. So I would ask the court to adopt the recommendations contained in the report, sentence Ms. Petty to a term of local incarceration, and hopefully that will send a stronger message to her that her behavior needs to be discontinued.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, as you can see from the report, I mean, her entire criminal history is these unfortunately very recent drinking and driving cases. This is her third one. Obviously, she was on a probation that did not go well. She is still on that, but likely to be discharged later this month. Is my understanding. She has done quite well since this incident on bond. Also personally, she's doing much better, taking advantage of some of the tools that she was given during her previous probation. Go to the report and talk to Ms. Petty. She realized as a young person she had a drinking problem and quit drinking for some 20 years. Unfortunately, got back into drinking recently. And obviously that clearly doesn't work well. In speaking with her, she would acknowledge that most of the time when she drinks, she ends up blacking out. And then she finds herself doing things like this. She can explain to you better, but she's unfortunately it took a bit to get there, but realized she just can't drink, and she's happy with that and wants to move forward in a life. She did for much of her adult life, just not drinking. So I understand that the prosecutor doesn't really have much optimism for her, and neither does probation, and maybe probation isn't what needs to happen. But I think in speaking with Ms. Petty, she's finally in the right mindset, the right frame of this. And unfortunately for these first two, drinking and driving, she wasn't. So I'm very hopeful she won't come back. I would look at most of her adult life. She wasn't in the system. She wasn't a problem. So with her finally accepting that she just can't drink, which is something she had previously accepted for over 2 decades and didn't create a criminal history, I'm optimistic for her that she won't be back on another. I understand why other people looking at her record would say, well, just keep doing this. But I would ask the court to take that into consideration. And I do think she could comply with probation if the court thought it was appropriate, because she is quite motivated to not drink, and she's basically working through the steps and things of that nature and doing a lot of the things that someone who wants to stay away from drinking needs to do.
Thank you, Ms. Petty. Anything that you wanted to say today?
I don't know. I'm ready for whatever you give me, but like he said, this time I'm honestly fully committed. Something made me realize my husband, when I called him from jail this time, he told me, you need to grow up. This is not high school anymore. And I think them words are what I needed to hear. And I'm fully committed. I've changed so much mentally, everything this time, everything's hitting me and I'm realizing and I guess you have sympathy with me and hope in me that I would make it through probation and the rest of my life without treatment.
All right, I did read through the report, so I'm familiar with what happened in this case. I'm familiar, based on the information in that report, with your circumstances, generally your past history and so forth. And the concerning thing to me about this incident is your blood alcohol level was quite high.
This time, yeah, because I was honestly getting worse.
Yeah.
And that was obvious, and even that kind of hit me. I seen a picture of a shot I had in my pocket. That the cop took to get, and I mean, that just hit me.
So that concerns me from a basis of public safety, that despite your two relatively recent incidents, you were still continuing to drink pretty heavily and drive in a condition where you presented a danger, not just to yourself, but to everybody else on the road. And I think you're very lucky that this didn't result in injuries to yourself going into the ditch, but more importantly, injuries to somebody else who might have been on the road at that same time. And because of that, I think there needs to be a penalty here so that you understand that this is conduct that as a community, we just can't tolerate because it does present a danger to other people. However, I think we also have to recognize that you did have a very lengthy period of sobriety, that you've had some recent issues, but that gives me some confidence that you can continue with sobriety going forward because you were able to do it for such a long period of time. That mitigates what I think should be a penalty here. So I generally agree that I don't think probation is appropriate. That's been attempted. It wasn't successful. I think it's on you at this point, rather than the court ordering it. It's on you to get the help that you need to make sure that you don't engage in this conduct further. I think some jail time is appropriate, again, for the reasons that I've stated. The charge would allow the court to sentence you to up to a year in jail. I don't think that's warranted given the circumstances, but I do think 90 days in jail is a reasonable sentence. It accounts for the danger that you presented to the community, provides a consequence to you, and shows other folks in the community that you're going to use alcohol, drive, present a danger, that there's a penalty to be paid for that. So the court is going to sentence you to 90 days in the Kalkaska County Jail. You do have credit for 12 days served. A crime victim's assessment of $75, court costs of $325, attorney fees of $350, and a $53 state cost. You do have the ability to seek an appeal of this sentence. If you wanted to file an appeal, you would need to do that within the next 21 days. If there are questions about that,
Okay, thanks.
Okay, Mr. Ziegler, do you have any objection to that?
No, Your Honor.
Is 30 days going to be enough time for that, Mr. Travis?
I believe so, because I believe my emails with the assessor is, the report's basically done. He's got a draft finished, so I was hopeful to have it last week, but we're not there, unfortunately.
Okay, and you said you don't have an objection?
No objection.
Mr. Way, have you had a chance to talk to Mr. Travis about this delay?
Yes.
Do you have any objection to that?
No, in fact, I think it's only helping me so far, so we can get all the facts straight.
Okay. All right, so the court will set this for a plea hearing status conference in about 30 days. Mr. Way, just make sure that you stay in touch with Mr. Travis during that period of time, okay?
Always.
Thank you.
Thank you, Your Honor.
Thank you. Thank you.
Mr. Barnett, were you ready on Ms. Johnson's case?
Yes.
You can take that a little early if you're ready.
Yes, we're early. You had to run into Mr. Gurman in the hallway, so we can get in and out before he creates a lot jam. That would be great.
Ms. Johnson, if you can, yep, right up to the podium there. We'll go on the record in People versus Aaron Johnson. This is file number 244985. The record should reflect Ms. Johnson present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
William Barnett, Your Honor, from Cadillac, on behalf of Ms. Johnson.
Thank you. This is the date and time set for a sentencing hearing in this matter. Ms. Johnson, have you had a chance to go through the pre-sentence report and speak to Mr. Barnett about that? Mr. Barnett, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any amendments to the score? Anything on behalf of the people for allocution?
Your Honor, I would ask the court to adopt the recommendations contained in the report. It's been difficult resolving these cases since Kalkaska has discontinued their sobriety court program. But I'm glad to see that the defendant was able to get into the sobriety court program in Wexford. It's a very valuable program. I think she's a good candidate for the program, and I'm hopeful that she will benefit from that program. I think it's much more beneficial both to her and to the community than anything else the court could do. So I would ask the court to adopt these recommendations. Thank you.
Thank you, Mr. Barnett.
Thank you, Your Honor. She took 30 days to go in a relationship, high school grad, bachelor's degree, substance abuse problem, mental health as well. Was stopped in a drive-through and drew attention to herself. And so that was a lucky thing to happen. It looked like a blackout situation. She does have a terrible disease. No prior felonies, couple misdemeanors. Would like to continue working in the medical field, in counseling, not currently working, passing on PPTs every day, twice daily. We do request sobriety court. We do want to thank the prosecution court, not in that order, this sobriety court team, probation office that's helped here. And court gave her additional time to figure this out, and so did the prosecutor. And thank you, everybody, for pointing out she's going in the program, and we'd ask that she continue and be formalized today if possible.
Thank you. Ms. Johnson, anything that you wanted to say?
I'd just like to say that I really appreciate everything that everybody's done to give me the opportunity to take responsibility for what I've done in a way that is, I never wanted to not be punished, obviously, but I would like to take responsibility in a way that seems productive. And I think that this time to bring sobriety under my belt. Going to be very beneficial, and I can't express much appreciation.
Right. I did read through the report. I'm familiar with your circumstances, your background and history, as well as the circumstances of this case. I am going to follow the recommendation of the sobriety court because I do think that that's a program that can help people, not only in getting sober, maintaining that sobriety, but learning different techniques, getting different tools to be able to prevent relapse. Is really important. Beneficial to the community, as Mr. Ziegler said, give you that opportunity. What happened here is really dangerous and really frightening from my standpoint, looking at this from public safety. It's really, really fortunate that you didn't hurt yourself or somebody else during this incident, and that it ended the way that it did with your car at a standstill. We're in with that kind of blood alcohol level, blacked out, where you really don't have any conscious control of what you're doing. It's frightening to me as somebody who could have encountered you on the road that day, and I hope it's frightening to you to think that you were out there driving around without having an idea of what you were actually doing. Once it happened, you could have woken up in a much different situation. And I want you to understand that I'm going to impose some jail time and hold it in abeyance. But I want you to understand that if you're not going to comply with sobriety court, if you're not going to, do the kind of things you need to do to maintain your sobriety, I'm not going to put our community in a position where you could victimize someone who's innocent. And I will do everything that I can in jail for as long as I can to prevent that, if you're not going to be working on your sobriety. So I really hope that you take that opportunity, because the flip side of that is I can't in good conscience let you out there in the condition that you're in. So I hope that you're successful. I think there's a lot of indications that you will be, and so I hope that that's the way that it goes, because again, that's best for you and it's best for the rest of us. But to the extent that it's stiff of a penalty as I can provide. So the court is going to sentence you to probation for a period of 24 months. I'm going to adopt as the conditions of that probation all the terms and conditions listed in the pre-sentence report, most important of which, of course, is that you participate in and successfully complete the sobriety court program. The court is going to impose 6 months in the Kalkaska County Jail. You do have credit for 1 day served. The court is going to hold that time in abeyance to be used at the discretion of this court and or the sobriety court program. Court is going to order that you pay a crime victim's assessment of $130, court costs of $325, a fine of $500, a DNA testing fee of $60, a $68 state cost, and any costs related to including participation fees for that sobriety court program. You do have the ability to seek an appeal of this sentence. Do you have those? The court officer is going to provide you with written copy of all rights. Mr. Barnett, if you could just have Ms. Johnson acknowledge receipt of those, please. All right.
Tell the court receive one.
You got a copy of that. Okay. Ms. Wagner, do you need Ms. Johnson to meet with you today?
Yes, please. Thank you.
So Ms. Johnson, after this hearing today, you're going to go across to the next building over to the probation department. Ms. Wagner. Otherwise, we'd like to go forward.
Thank you.
Hope to see you in about 12 months.
Any word on Ms. Kellen?
She is lodged and should be, she was scheduled. They have them on, I have her on Zoom at 10 o'clock.
Mr. Travis?
He similarly is in some level of custody.
Judge, we do have Mr. Galt here early. I don't know if you want to do that early. And then
Yes, you can do that.
they just informed that they've got people from the Wexford jail. And Ms. Bunning is on Zoom for the plea, so whenever Wexford jail please, we can do that too.
No. Hun and Lambert and Call are all lodged. They're
Yeah,
here.
okay, thank you.
Oh, Hun is physically here?
Yeah.
Okay. Mr. Hun is here?
Yes.
Oh, can we bring him out? Oh,
Okay. So is jail here like being built or?
We just don't have corrections officers to staff.
Oh,
So we've been having people in Wexford for 2 or 3 years.
yeah, I know there's one, I just, you know, it was like 20 beds and, you know.
No, we have a perfectly fine facility. We just don't have the necessary personnel.
Personnel, wow.
Yeah.
Podium there, please. We're on the record in People versus Thomas Hunn. This is file number 255028.
Travis, on behalf of
Travis, how do you want to proceed with Mr. Hunn's case today?
You would be asking for an adjournment. There's a couple things to take up. Yesterday, Mr. Hunn and I, along with Mr. Ziegler, were in front of Judge Bunning. He unfortunately has a new felony file that is coming up that hopefully will go to your honor. I don't know how that works, but, it's also a drinking and driving case, and we have a global resolution, but one of the charges is an armed. So we basically need the new file to be in front of the honor. So, please. So that is what we ultimately have to do. And issue that came up, I believe, but I don't do the arraignments that Mr. Hunn was arraigned on a bond violation on this case. Okay. If he wasn't, I guess I would ask the court to revoke his bond on this case. I'm not sure if that happened or not.
Signed a bench warrant back on March 10th. But I had not been aware that he was rearrested on something new. So no, he has not been, that bench warrant is still out there. It hasn't been returned. So is there any objection to revoking the bond at this time?
No, you're not.
Okay, so if you could just prepare a stipulation order on that, Mr. Travis.
Thank you.
And if you want to make that retroactive to when Mr. Hunn was arrested.
Thank you.
I don't have an objection to that. In terms of the new file, has that hasn't been bound over yet?
Yes.
Okay, so we'll have the clerk's office assign that new file to me. I will have both files set for a plea hearing. Is that something that we should set for May motion day?
Yes, Your Honor. I think we're largely in agreement.
So we'll set it for the May motion day. Mr. Ziegler, anything else that we need to address?
No, Your Honor.
Mr. Hunn, do you have any questions at all?
I didn't understand a thing you guys was talking about.
Okay, Mr. Travis.
We've got a resolution of both files. All right. We're gonna hopefully get the other file we waited on yesterday in front of Judge Mertz and come back in a month.
And in the meantime, I'm still in jail.
Correct.
Okay. All right.
All right, so the record should reflect Mr. Travis has had an opportunity to consult with Mr. Hunn, and we'll go forward with that plea hearing in May. And that's all for today, Mr. Hunn. Thank you.
Thank you, sir. What's that step? That gentleman. Oh, God.
Our next hearing is set for 10:30. People versus Weaver.
Mr. Weaver is in the courtroom.
This is file number 244983. Ms. Weaver, if you'd like to come forward, please. The record should reflect Ms. Weaver's present here in the courtroom. Mr. Travis, how did you want to proceed there?
Your Honor, the discussion in cases Ms. Weaver and here, we are to an agreement. There's a contingency to that agreement. Ms. Weaver has made progress with getting a loan, but she does not have the money in hand today. But given that Ms. Weaver assures me that this is going through, I'm comfortable with her entering the plea. A contingency of that is the restitution would need to be paid prior to sentencing. But in light of all that, it's my understanding Ms. Weaver would like to accept the plea offer contingent on the restitution being paid prior to sentencing to the 1-year misdemeanor version of the current felony charge.
Okay. Mr. Ziegler.
Fair statement, Your Honor. If you were vulnerable adult abuse, 200 to 1,000, which would be a 1-year misdemeanor.
Okay. Ms. Weaver, have you had an adequate opportunity to speak to Mr. Travis about this plea agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help
Yes,
you
sir.
God?
Yes.
Thank you. We're making a record, so if you talk at the same time as me, it may not be clear, so we have to take turns, okay? Ms. Weaver, you understand that by pleading guilty to this misdemeanor embezzlement, that carries with it a maximum possible penalty of up to 1 year in jail?
Yes.
Are you currently on any kind of probation or parole?
Yes.
With that penalty in mind, then what is your plea to that charge today?
Guilty.
Now you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself at a trial if you wanted to. You understand all those rights?
Yes.
Understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Okay. Mr. Ziegler, I'm assuming that if the restitution wasn't paid, that you would withdraw.
I would, Your Honor.
So if for some reason, Ms. Weaver, that you don't pay that restitution that we've been discussing, then the prosecutor would withdraw this plea agreement. We'd go back to the beginning of your case. You would get all those rights I just talked about back. Okay.
Yeah.
Has anyone threatened you with anything to
No.
get you to plead guilty?
No.
Has anybody promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty?
Yes.
So the date that I have for the circumstances back in October of 2023, is that the correct time
Yes.
frame? And at that time, did you have some type of responsibility to manage money or property of a vulnerable adult, Miss Bresnahan?
Yes, that's my aunt.
Okay. All right. And did you have access to money or property that belonged to her?
Yes.
Okay. And is she elderly? Does she have some mental capacity?
Yeah, she's elderly. She moved up with us. She has dementia.
Okay.
It wasn't so bad at the beginning, and I guess, I don't know.
Oh, obviously you knew about that condition.
I did. I didn't think it was that terrible, though. I mean, at the beginning, it wasn't that bad.
Okay. And did you take or use some of that money or property that belonged to her and use it for your own benefit as opposed to her benefit?
Used it for the family's benefit, basically. I tried to start a business and get things going with that.
Okay.
So I could be there on the property and take care of her and my mom as they got older.
Okay, but that money wasn't being used to pay for her care?
No,
or things
no.
like that? Okay. All right, Mr. Ziegler, you said, oh, did that happen here in Kalkaska County?
Yeah, Rapid City.
Oh, Mr. Ziegler, any additional questions?
And Ms. Weaver, the amount that you took was at least $200?
Yeah, at least, yes.
That's fine.
All right, Mr. Travis, with the factual basis.
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Thank you. Ms. Weaver, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this added charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. I'm going to set that sentencing 60 days out. Do you have any objections to that?
No, Your Honor. Thank you.
Mr. Ziegler?
Okay.
And So Ms. Weaver, it's just important that you stay in touch with Mr. Travis and that you make sure that gets paid within that 60 days, because as I said, if it's not,
Yep.
then we have to start over again.
Absolutely. Thank you.
All right, that's all for today. Thank you. Oh, one other thing, Ms. Weaver, I'm sorry. Ms. Wagner, are you there?
Yes,
Do you want Ms. Weaver to stop over at your office here today?
yes, please. Thank you.
Okay.
Oh,
So Ms. Weaver, after this hearing, you need to go across the way to the probation office and meet with them.
I know where Miss Wagner is. Thank you.
Okay, thank you. All right, ma'am, can you tell me your name, please?
Megan Kellen.
Okay, the record should reflect that Ms. Killen is, excuse me, Killen is present by Zoom video. This is file number 255017. Again, Ms. Killen is present by video from Blacksburg County Jail. Okay.
I didn't say we're, yeah.
Kyle Travis on behalf of Mrs. Kellen.
Mr. Travis, can you tell me the status of this file today?
Your Honor, it is almost, it is different. They're completely different files, but the same situation that Mr. Hunt was in. We waived a prelim yesterday. We have a global resolution that in this, these cases, that global resolution would require both files. There's a piece in each file. We did, Your Honor, signed a stipulation to cancel this bond on this case. So we would similarly be asking for just a 30-day adjournment to have it set for a plea. And if Your Honor could have the case assigned to yourself if possible, that would obviously make things work better.
Okay, Mr. Ziegler, any objection to that?
No, Your Honor, that's all accurate.
Ms. Killen, were you able to hear what Mr. Travis said?
It was, yep.
Okay, do you have any questions at all?
I do not.
All right, so I'm going to set your case for hearing in May for a plea hearing along with your new file, and we'll address both of them at the same time at that time, okay?
All right, sounds great.
Actually, they're both already assigned.
Oh, good. Excellent. Okay. All right, thank you. That's all for today, Ms. Killen.
Thank you.
Have anybody else in Wexford?
I don't, I'm not sure.
Okay. Our next hearing is at 10:45 with Ms. Brister. Mr. Travis, you can just let me know whenever you're ready on that file.
Thank you.
We'll take a short recess. we're on the record in People versus May. This is file number 24826. The record should reflect Mr. May is present here in the courtroom. If I can have counsel put your appearances on.
Your Honor, Ryan Ziegler on behalf of
Scott Isles, on behalf of Mr. May.
Thank you, Mr. House. This is your motion regarding the terms of probation. How did you want to proceed with that today?
Well, Your Honor, you got that conglomeration I threw on your law clerk's desk, much to his dismay, I'm sure. We haven't heard from the prosecutor. It's my understanding from talking to him, he has no objection. Maybe you should start with him and see what he thinks.
Okay, Mr. Ziegler.
Your Honor, I don't have any particular objection to the relief being requested. In terms of the community service, I would say that I think it will be rather onerous for Mr. May to try and complete that amount of community service, given that he's already in sobriety court and given his medical issues, which I'm sure the court has had a chance to review the motion and is aware of, but I'm assure the court they are genuine. As to the other two matters the defense has raised, we don't take a particular position. We leave it to the discretion of the court.
All right, Agent Barup, did you have any input on this?
I have no objections, Your Honor, either. Mr. May has been doing well. He was recently moved to our telephone reporting system. So again, I have no objections.
Okay, I did review all the materials that were submitted, including the transcripts. And given number one, that there aren't any objections either from the prosecutor or probation, I also agree that the changes would be appropriate. So Mr. Isles, if you could just prepare an order that the court can sign, and then we can submit that to probation. And then Agent Barup, I'm assuming, would you issue an amended order of probation for me to sign then?
Yes, Your Honor, I will.
Okay. Mr. Isles, anything further on this file today?
You have a good day.
Okay, thank you.
Thank you.
Thank you, sir.
Thank you, Ryan.
Thank you.
Mr. Travis, were you ready with Ms. Brister's case?
Yes, sir.
People versus Brandy Brister, file number 255018. The record should reflect that Ms. Brister is present here today in the courtroom. This is the date and time set for sentencing. Brister, did you have a chance to go through the pre-sentence report and speak to Mr. Travis about that?
Yes, sir, I did.
Okay. Mr. Travis, are there any additions, deletions, or corrections?
No, I'm not aware of, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, very little. I think the recommendations contained in the report are appropriate. I'd ask the court to adopt them. Ms. Brister has some minimal criminal history. I think a term of probation is appropriate in this case. I'm hopeful that she understands that this kind of conduct, if it continues, will result in increasingly more serious punishments. I think she understands that. But be that as it may, Your Honor, I think given her record, a probationary sentence is appropriate, and either she will learn from that and do well on probation, or she won't and she'll face the consequences of that. So I would ask the court to adopt the recommendations.
Thank you. Mr. Travis?
Largely, I would agree with Mr. Ziegler. I appreciate probation wanting to give Ms. Brister an opportunity. She did, as is noted, have a previous probation, which she did not successfully complete the delay, and there were issues, but she also, much of that was doing fairly well on probation. So I know probation could have said, hey, she wasn't successful, I don't want her on again. But Ms. Brister appreciates it, and I appreciate it. And I think hopefully Ms. Brister is, going to do better this time than last time. She didn't do horrible last time, but she didn't do good enough. And this time she wants to do good enough. We've talked a bit about her life and her path, and some of that's in the PSI. Obviously, narcotics, drugs have put her in a bad situation twice. And she seems to realize that she can't do that anymore. She's also unfortunately lost both her parents now, and they had been a large support for her. Really kind of helped keep her whole family together So she really needs to succeed here for her own children, because kind of the pillars of their family unit are not there. So she needs to become that person, and she wants to become that person. So she's got a pretty high motivation. So I'm hopeful it can happen.
All right, thank you. Ms. Brister, anything you wanted to say today?
Pretty much think Mr. Travis covered it. I mean, I was in a hard spot, and I know better. I know better. My parents raised me better, and like he said, I lost both my parents. I gotta be there for my kids. I'm the most stable one that my children have. So my daughter is 8. Other than that, yeah, I think that's, yeah. Thank you for your time.
Okay. I read through the report. I'm familiar with you. You were in front of me on a previous case. So I'm already kind of familiar with your background and circumstances. And then reading this report gave me information about what happened in this case. And I agree with the recommendation. I'm going to place you on probation with some jail time held in abeyance. But you know, you're starting to kind of run out of chances here. And if you have young children that are depending on you, you are not going to be able to take care of them from jail.
Absolutely.
And if you continue on this path, that's where you're heading, is jail or worse. Because there are some pretty stiff penalties for the types of substances that you're involved in and the kind of activity that you're around.
Yes.
Your trafficking is going to get you sent to prison on the first offense. So, you know, you could be looking at some serious prison guidelines. Continue to hang around these people and engage in this. So you need to get it straight, and you need to do it now. You seem like such a nice person when you're in here. You know, I think you probably have a lot of good qualities that if you focus on that, move on to this. And I hope that you do that, because I don't want to see that for you.
I appreciate that.
But you really are, you know, you're gonna put me in a position if this happens again where I don't have a choice.
Yes.
So
and we won't be in that position. So
good.
Yeah.
I hope that's the way it goes, and I think it can go that way.
Absolutely.
Really, really motivated, and hopefully you are. So I'm gonna place you on probation for a period of 12 months. I'm gonna adopt as the conditions of that probation all the terms and conditions listed in this report. The court is going to impose 6 months in the Kalkaska County Jail with credit for 3 days served. The court's going to hold that time in abeyance to be served at the discretion of the court. The court is going to order that you pay a crime victim's assessment of $130 or costs of $325, attorney fees of $350, $68 state cost, and supervision fee while you're on probation of $30 per month. You have the ability to seek an appeal of this sentence. We're going to provide you with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. Mr. Travis, if you can have Ms. Brister acknowledge receipt of that, please. And Agent Wagner, did you want Ms. Brister to check in with you here today?
Yes, please. Thank you.
Brister, after you leave court, you can go over to Agent Wagner's office and meet with her.
Thanks, I appreciate it.
Wexford's going to get Mr. Inman on.
Your Honor, I did have an opportunity to speak with probation, so I was wondering if I could talk to Mr. Inman briefly in the breakout room.
Yes.
Additionally, Your Honor, just so you know, albeit not my case, Mr. Connolly had a proffer this morning, and he thought it was going to take an hour, but he still thinks that he'll make it by 11:15. But I did tell him that you had other things on your docket scheduled for 11:15, but he should be here very close to 11:15.
Okay, sounds good. spirit again and ready for more defendants. Big short recess. All right, Mr. Inman, are you able to hear me okay? All right, I'm gonna put you into a breakout room. Your attorney would like to speak with you, so I'm gonna give you a chance to talk to him in a breakout room so you can have a confidential conversation. Okay, that should be going now, Mr. Seeger. So Mr. Inman, you may have to press a button there or something to be able to join the breakout room with Mr. Seeger.
You know, you're a young guy.
Inman, are you able to hear me?
Yes, sir.
Okay. All right, we're back on the record in People versus Joshua Inman. This is file number 234853. The record should reflect Mr. Inman is present today by video from Wexford County Jail. If I could have both counsel put your appearances on.
Thomas Seeger, appearing with an update from Mr. Inman.
All right, we're on the record here today, I believe as a result of a probation violation. Is that correct, Mr. Seeger?
Yes, Your Honor.
Okay, how do we want to proceed?
Your Honor, it's my understanding after speaking with the Department of Corrections that to the extent that Mr. Inman enters into a plea, that the recommendation would be that he be discharged unsuccessfully with credit for all time served. And so to that end, Your Honor, it's my understanding that Mr. Inman wishes to enter into a plea. And then he would have no objections to immediate sentencing to the extent that the court is going to follow the recommendation of the department.
Okay, Agent Barrett, are you the supervising agent?
Yes, Your Honor.
Okay, is that a correct statement?
That's correct, Your Honor.
And do you know how much jail time Mr. Inman would be entitled to on this file?
Oh, I don't have the exact number in front of me, Your Honor. If you want to give me a second, I can look at that.
Okay, yep, I'll go forward with the hearing and then we can address that in a minute. Mr. Inman, is that correct? Did you want to enter a plea to the probation violation today?
Yes, sir. Yes, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God. Yes, Your Honor.
Thank you. You can lower your hand. Mr. Inman, you understand that you have the right to have a hearing as to whether or not you violated your probation?
Yes.
And you understand that by pleading guilty, you're going to be giving up that right?
Yes.
Okay. Also, by pleading guilty, it could subject you to the maximum possible penalty on your underlying charge, which is up to 5 years. Do you understand that?
Yes, yes, Your Honor.
Okay, so just to clarify, that's the maximum penalty on the charge that you're on probation for. That doesn't mean that that's what your sentence is going to be in this
No, I
case.
understand. I have a comprehension problem right now for a lot of things. So I just the 5-year expansion was a bit of a choke up for me. I didn't know it was that far.
No, and that's understandable. And if you have any trouble or you want me to clarify anything, just let me know and I'm more than willing to do that, okay?
Yes, Your Honor, thank you.
So, and you indicated that you do want to plead guilty to the probation violation, is that correct?
Yes, Your Honor.
Okay, has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've talked about here on the record today?
No, Your Honor.
And is it your own free choice to enter into this plea?
Yes, Your Honor.
Okay. Back in August of 2024, were you on probation out of Kalkaska County?
Yes, Your Honor.
And were you aware that one of the conditions of your probation was that you were to not violate any of the laws of the state of Michigan?
Yes, Your Honor.
Okay, and did you violate that condition by being in possession of controlled substances that were not prescribed to you?
Yes, Your Honor.
Okay. All right, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you did violate your probation as alleged at count 2. The court will accept a guilty plea. And in terms of moving forward with sentencing, Agent Barrett or Mr. Ziegler, was there anything that either of you wanted to indicate to the court?
I don't have any comments, Your Honor.
Agent Barrett?
Sorry, Your Honor. No additional comments or concerns, Your Honor.
Were you able to determine the amount of jail credit?
Trying to find the exact date, Your Honor. I'm looking through my case notes. I believe it was on March 9th that he was arrested, so I have it calculated at 31 days since his arrest, but I'm trying to clarify that.
Okay. Thank you. Mr. Seeger, anything on behalf of Mr. Inman today?
Your Honor, on behalf of Mr. Inman, I would just ask the court to consider discharging him unsuccessfully from probation with credit for all time served, as I discussed with the Department of Corrections. Unfortunately for Mr. Inman, unrelated or somewhat related to this, it's my understanding that he's subject to sentencing in Grand Traverse County on Friday, at which point I'm not entirely sure what will happen, as I'm not his attorney record. However, to that end, Your Honor, either Grand Traverse County will give him a sentence of some sort, or it will place him on probation, but there's probably no real point to continue him on probation through Kalkaska County. I would just ask the court to discharge him successfully and allow Grand Traverse County to exact whatever sentence they believe they need to do.
All right, thank you. Mr. Inman, was there anything you wanted to say today?
Nothing that has to do with here. I just, I fear for my safety inside these walls, that's all.
Okay.
Your Honor,
All right.
I was able to clarify that. He was arrested on the 29th of March. He has credit for 11 days served up to this point, as of today's hearing.
Okay. All right, so Mr. Inman, during the break here, I had a chance to review your file so that I could familiarize myself again with your case. I had an opportunity to do that based on that information, as well as what the lawyers have had to say here today in terms of your current circumstances and the plea. I do find that the recommendation is appropriate. I don't think additional jail time is going to accomplish the purposes of sentencing here. So I think the amount of time that you served thus far is adequate, and that discharge unsuccessful from probation is an adequate penalty as well. So the court is going to order that you be sentenced to time served. That's 11 days in the Kalkaska County Jail with credit for 11 days served. The court is going to order that you be unsuccessfully discharged from your probation here in Kalkaska County, and that any outstanding fines and costs be preserved. You do have the ability to seek an appeal of this sentence. You will be provided with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. Agent Barrett, is there anything any further that we need to address on this file today?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
Mr. Seeger?
Your Honor, the only question that I had, and he does have a newer file through Kalkaska County District Court, is whether or not he'd be released into the care and custody of Grand Traverse County, clearly because he has sentencing on Friday and currently housing him. But I don't know if that's an administrative question for which the court really has an answer one way or another, but I just assume he go to Grand Traverse County so that we don't have to transport him or do anything else, or they can come get him from Wexford or Kalkaska County.
I don't know that I have any control over that. He's going to be discharged from this file, so my jurisdiction is going to end here today. So I think that's an administrative call for the jail to make.
Thank you.
Okay, that's all for today, Mr. Inman. We're going to go ahead and disconnect at this time.
Sorry, I just wanted to let you know, and I was gonna say it loudly so everyone could hear, they're gonna be testing the fire alarms today between about noon and 12:30. So I just didn't want anyone to be startled. Tell everybody.
I'll make the announcement if it looks like we're going to be here. But thank you.
Yeah, yeah.
All right, do we have Miss Bunning or Bunning?
Ms. Bunning, she should be on Zoom, just from the Wexford jail. Terry, she's not in person brought here, right?
Is Miss Bunning here?
No.
disconnected.
I take that back. Yes, 11:15. She was scheduled for Zoom.
Oh,
I can contact them again if you.
okay, they're back. All right, ma'am, are you Pamela? Is it Bunning or Bunning?
Bunning?
Bunning, okay, this is that your name?
Yes.
Okay. We're on the record now in People versus Pamela Bunning. This is file number 255029. The record should reflect Ms. Bunning is present today by video from Wexford County Jail. If I can have counsel put your appearances on.
Ryan Ziegler on behalf of people you're on.
Thank you, I'm Mertz. I'm appearing on behalf of Ms. Bunning.
All right, Mr. Gurmurthy, can you tell me the status of this file here today?
Yes, Judge, today is set for our first jury status conference. Mr. Ziegler and I have this matter resolved. My understanding is Ms. Bunning would enter a plea this morning to an added count of possession of a controlled substance less than 25 grams. That's a 4-year felony and or $25,000 fine. The remaining counts would be dismissed. There's also a truthful testimony component as to Mr. Terrence Wood. And Mr. Ziegler does not object to day-for-day credit if Ms. Bunning would enter into an inpatient rehab facility to successfully complete that treatment.
Okay, and would we be taking the plea to the factual basis that count 1 as charged?
Correct.
Okay, Mr. Ziegler?
That's all accurate, Your Honor.
Ms. Bunning, were you able to hear that?
Kinda.
Okay, have you been able to talk to Mr. Gurmurthy about the plea agreement in this case?
Yes.
Okay, and what he said was that you would be entering a plea to a 4-year felony of possession of a controlled substance. And in exchange for that, the possession of methamphetamine, which is a 10-year felony, would be dismissed along with the habitual 4th offender enhancement.
Yes.
Is that your understanding?
Yes.
Is
Yep.
that's the same agreement that you've discussed with Mr. Gurmurthy before?
Yes, yes, Your Honor.
Is that how you wanted to go forward today?
Yes.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. You can lower your hand. Ms. Bunning, are you currently on any kind of probation or parole?
No, sir.
And as I indicated, the charge that you're going to be pleading to is possession of a controlled substance. That's a 4-year felony and or a $25,000 fine. Do you understand that?
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights,
Yes, sir.
and you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, any appeal of your plea here today would have to be by leave to the Court of Appeals. That means that you don't have an automatic right to appeal your plea. You would have to ask that court to hear your case. And if they said no, you wouldn't be able to go forward with that appeal any further. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we've said on the record here today?
no, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty of this charge?
Yes,
The information I have indicates that this happened on or about January 15th or 16th of this year, 2025. Is that the correct time frame?
yes,
At that time, were you present here in Kalkaska County?
yes, I was.
And while you were here in Kalkaska County at that time, did you have possession of some methamphetamine?
Yes, I did.
Did you know that that's what that substance was?
Yes,
Did you have any legal right to have any amount of it at that time?
no, sir.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Kerman?
Defenses as well, Judge, thank you.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Germer?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Germer?
And defenses as well, Judge.
Ms. Bunning, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be transported here to Kalkaska for purposes of that hearing. And in the meantime, someone from the probation department will be in touch with you for a pre-sentence report.
Okay.
Mr. Ziegler, anything further on this file today?
No, Your Honor.
Mr. Germer?
Judge, I just wanted some clarification. Ms. Bunning was able to secure some treatment at Bear River Health. They require 14 days notice to then make arrangements to pick her up and get her bed ready and so on. She does want to go into treatment. Does the court want to wait till she's sentenced to make that decision, so we have all that information at the time of sentencing? Or if she can go sooner, would the court object to that?
Well, I doubt that I'm going to have an objection to Ms. Bunning going to treatment, but I do think we need to have the sentencing hearing first so that that's taken care of.
Okay, then I'll submit all the necessary documents to the agent and Mr. Ziegler, so we'll have that at the time of sentencing, Judge.
Okay.
Thank you.
All right. Thank you. Do you have any questions, Ms. Bunning?
Nope, I don't think so.
Okay. Thank you. That's all for today.
All right, thank you.
I think we're ready for Mr. Powell.
You said Lambert, correct?
What's that?
You said Lambert.
Mr.
Galt is down, Lambert's.
I know. I don't think we have Mr. Lambert's attorney. Do we?
Yeah, he's with him.
Well,
Oh,
Mr.
yes.
Conley is here. I think he was meeting with him.
Oh, I didn't know that. Okay. Yeah. Yeah. Great. Mr. Connolly, Mr. Lambert, if you can go to the podium there, please.
Yes, Your Honor.
We'll go on the record in People versus Anthony Lambert. This is file number 255020. The record should reflect Mr. Lambert's present here in the courtroom. If I could have counsel put your opinions.
Yes, Your Honor.
Ryan Ziegler, on behalf of people, Your Honor.
Matthew Conley, Your Honor, on behalf of Mr. Lambert.
This is set for a status conference, scheduling conference today. Mr. Connolly, can you tell me where we're at with this?
Yes, Your Honor. There's been a plea offer made whereby Mr. Lambert pleads guilty to count 1, controlled substance possession of methamphetamine. That being the 10-year felony, the habitual offender would be dismissed. He would like to take advantage of that offer, Your Honor. We have reviewed verbally his trial rights. I don't know if Your Honor has a form you would like to fill out.
I'll go through them with
Okay.
him here on the record.
And he is on parole, Your Honor, so he understands. I've explained the consecutive nature of the sentencing. And in my experience, what the Department of Corrections generally does with the older case, but he is on parole, I believe, for the same conduct. So out of Your Honor's court.
Thank you. Mr. Ziegler, is that a correct statement of the plea offer?
It is, Your Honor, count one with no habitual offender.
Right, Mr. Lambert, have you had adequate opportunity to speak with Mr. Connolly about this plea agreement?
Yes, sir.
And what we've discussed here today, is that the same agreement that you discussed with him previously?
Yes, sir.
And is that how you want to proceed today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Lambert, you understand that the maximum possible penalty that you can face in this case would be up to 10 years and or a $15,000 fine?
Yes, sir.
And as Mr. Connolly indicated, because of your parole status, any sentence in this case would have to be consecutive, in other words, back to back, as opposed to at the same time as any sentence you would receive for violating your parole.
Yes, sir.
Do you have any questions about that part of it at all?
No, sir.
In light of all of those penalties, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty, including the right to have a trial.
Yes, I do.
Also, any appeal that you would want to make of this plea today would have to be by leave to the Court of Appeals. That means that you don't have any automatic right to appeal it. You'd have to ask for the Court of Appeals to hear that case. If they said no, then you couldn't go any further with that appeal. You understand that?
Yes, I was explaining.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty because you are in fact guilty?
Yes, sir, I am.
The information I have indicates this happened on or about January 15th or 16th of this year, 2025. Is that the correct time frame?
Correct, sir.
At that time, were you present here in Kalkaska County?
I was.
And while you were present here in Kalkaska County at that time, did you have possession of some methamphetamine?
Yes, sir.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No, sir.
All right, thank you. Mr. Ziegler, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Connolly?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
There you go.
Mr. Connolly?
No, Your Honor, thank you.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Connolly?
Yes, Your Honor.
Mr. Lambert, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing along with your attorney. Prior to that, someone from the probation department will be in touch with you for a pre-sentence report. Mr. Ziegler, anything else we need to address on this file?
There you go.
Mr. Connolly?
No, Your Honor, thank you.
Thank you, that's all.
Mr. Gold, right there.
For a civil plea.
Oh, okay. No, but I don't.
Instead of me.
Mr. Galt, if you can have a seat there, please. We'll go on the record. This is People versus Richard Galt, file number 244943. The record should reflect Mr. Galt's presence here in the courtroom today. If I can have counsel put your appearances on.
Remember Ryan Ziegler on behalf of the people.
I think you're ready to go around on behalf of Mr. Galt.
We're here today. Mr. Gurmurthy has filed a motion to withdraw as Mr. Galt's attorney. I guess one thing that affects the court's consideration here, I want to make sure the record is clear. Again, because I think there's a difference between Mr. Galt, you asking the court to appoint a different attorney for you, and Mr. Gurmurthy asking to withdraw from the case. So I want to make sure that we're clear on the record which of those two I'm dealing with.
Well, I'm gonna ask that I withdraw from the matter. I think the other issue, which, and I'll leave it to the court's discretion. Mr. Galt is requesting another counsel. There's a process to that because the court no longer appoints counsel. Mr. Galt has been made aware of that. Mr. Galt has been made aware of that by Mr. Thompson, who is the indigent defense counsel.
Actually, before we go further, Mr. Thompson is, let me bring him in.
Okay, right, and I was just gonna say, Mr. Thompson wanted to attend this hearing as well.
Your Honor, I've filed several motions
Okay,
through the courts.
okay, and we'll talk about that in just a second. Mr. Thompson, are you able to hear me okay?
I can hear you. Thank you.
All right, we just got started with the hearing involving Mr. Galt. I asked for a clarification as to whether or not Mr. Galt was asking for different appointed counsel or whether Mr. Gurmurthy was asking to withdraw from the case, because to me, those are two different considerations, or whether it's both. And so we've just begun that discussion, just to bring you up to speed here. So Mr. Gurmurthy, you're asking to be withdrawn. Mr. Galt, are you asking for a different appointed counsel as well?
Yeah, well, Your Honor, first time I filed a motion, I was assigned, and this was back in July of 2024. I was assigned a new attorney because Mr. Gurmurthy was never actually. See, what happened is Mr. Seeger assigned himself to my case with a direct conflict of interest. You know, he represented the victim in the case, the victim's boyfriend, the victim's sister, the victim's sister's boyfriend, both of the victim's children. And it took me 5 months, 150 days before Mr. Seeger was willing to withdraw and acknowledge the conflict issue. So then, since there was a conflict issue, he handed me off to Mr. Thompson. Well, in the process, I got this letter here from Mr. Seeger, says, I have enclosed the substitution of counsel. If you wish to have alternate counsel, this is your opportunity. And then again on this page, second page, I have enclosed the substitution of counsel. You may execute this form if you no longer wish me to be an attorney. You may. So this was with Michael Horwitz. I said, well, Mr. Seeger, Michael Horwitz and you share an office, so it's still a conflict issue. So he goes, okay, well, I'll see what I can do. He goes, you have anybody else that you would be interested in? I'm like, well, I talked to Patrick Cherry. He said he'd take the case if you'll appoint him. Mr. Seeger talked to Patrick Cherry. Patrick Cherry said that he wanted $350 an hour. Mr. Seeger said, well, we ain't paying that. Okay, whatever. So he comes to me and he's like, I talked to Mr. Gurmurthy. He said he'd be willing to take your case. He goes, I'll send you substitution of counsel paperwork and you can sign and return to my office and we'll get Mr. Gurmurthy appointed to your case. So he sent me the substitution of counsel paperwork, which I have a copy of here. I got the original back at the cell. I never got a chance to sign it. It's never been signed to send it to me. It's never been ordered by a judge that Mr. Gurmurthy was even appointed to me as counsel. Okay, so I'm like, you know what? I'm not going to say nothing because if things go bad, I can always be like, Mr. Gurmurthy was never actually legally appointed to my case. So that's automatic grounds for an appeal right there. So I didn't say nothing. Well, then Mr. Gurmurthy refused to call any witnesses that I wanted him to call at the preliminary exam. So that's when I was like, you know what? Heck with this, I'm filing a motion to withdraw or filing a motion for substitution of attorney. So I filed a motion through Mr. Thompson because the case had to get handed to Crawford County because of the conflict issue out of Kalkaska. So I filed a motion and I was appointed a new attorney. right here, for my August 1st, 6th court date is Shauna Sullivan. Right here, she's an insurance fraud investigative attorney out of Braintree, Massachusetts, that is allowed to practice law in Michigan. So I contact her and she's like, Mr. Galt, I'm not a criminal defense attorney. I'll contact the courts and get this straightened out. So she contacted the courts and I get a second notice for the same court date that says, this hearing will be held via Zoom. Defendant is lodged, notice resent with no change other than defendant's attorney is now Guramuthi. So I got appointed a new attorney and reassigned Mr. Guramuthi. So then we go to the court date on August 6th, Your Honor, Zoom, and I'm in Wexford Jail. And you're like, okay, Mr. Guramuthi, how's 90 days sound for continuance to file motions? And Mr. Guramuthi says, your judge, how about 120 days? And you were like, will that be enough time? And he's like, absolutely. So then on December 3rd, 14 months after I was arrested, no motion's been filed. I'm going to use your exact words, Your Honor. Mr. Guramuthi, you didn't show up today to court. That is unacceptable. Mr. Guramuthi, you didn't file your motions today. That is unacceptable. That's unacceptable. That's ineffective assistance of counsel. 14 months later, that one motion's been filed on my behalf, and you granted him 120 days to file motions. I've never even got a copy of the motions that were filed. He gave me a rough draft of these motions that had my case and Joe Cunningham's case mixed together. He came to the jail 2 days before court, the court date where the motions were filed on time, to do the corrections. He's like, I'll get you the corrected copies that I'm going to file with courts. I've still never seen a copy of the motions that were filed. I don't know what copies of motions were filed. So then I asked for transcripts, because I wanted transcripts, where you, Your Honor, stated, Mr. Guramuthi, you not showing up today is unacceptable. You not filing motions on time is unacceptable. I want them transcripts where you, Your Honor, said that, in case it comes to an appeal purpose. And then when we come to the motion hearing on January 24th, you're like, well, I'm not going to have you and Mr. Guramuthi both argue in motions. I said, all right, well, I'll let Mr. Guramuthi argue motions. So you're like, Mr. Guramuthi, do you have anything to say about arguing these motions? Mr. Guramuthi's like, no, Your Honor, I'm good. Well, if I'd have known he wasn't going to argue them, I would have argued them, Your Honor. You know what I'm saying? So there's another ineffective assistance of counsel. I've begged Guramuthi to file several motions, and I've got a list of the motions here. I even researched case laws for him for his motions, and he refuses to file motions. He refuses to he refuses to request body cam footage of the search in its entirety. I want officer activity logs. I've got proof with me today of Detective Nichols perjuring himself on the stand under oath. I've got right here.
Well, let's try to stay on the lawyer issue, because that's.
Well, this is a lawyer issue. This is stuff I'm pursuing.
Well, I'm not going to make any decisions about what police officers did or didn't testify to today. So tell me how that relates to your attorney issue.
Because I've asked Mr. Guramuthi to address this with Mr. Ziegler and be like, look, we can discredit your witnesses. We can work some kind of a deal, something. You know, I got my deal from Mr. Ziegler, Your Honor, was on 86 district paperwork with the wrong case number on it from the prosecutor. That was his deal. Another thing is I asked Mr. Guramuthi to file a motion, because you know what, Your Honor, felony complaints, citations, anything signed in those are made under oath, sworn to. You got to be sworn to. I got a felony complaint right here with the paperwork filed from the prosecutor, signed with the complaining witness that says I committed second-degree homicide on 10/30/2023 in Cold Springs Township. That's 2 days after the descendant was dead. I got a felony complaint right here that says The plaintiff witness has filed a sworn complaint in this court stating that on a date and location described above contrary to the law, Mr. Galt of Gold Springs Township committed second degree homicide on 10/30/23, 2 days after the defendant was dead. I've asked Mr. Guramusi to file motions to quash charges due to the fact that I was illegally arrested, illegally arraigned on a felony complaint and a felony warrant that contains false information. Was never signed and dated by anybody, the return and tabulation, where I was arrested. I've requested the SIDNET reports, which is an electronic report record for arrest, to find out who even served the arrest record, because I never seen a felony warrant for 17 months. And I knew that the felony warrant was based off a felony complaint, which was inaccurate, and I couldn't do nothing without the actual felony warrant showing that I was illegally arraigned, illegally detained, and illegally arrested based on a complaint and a warrant with false information on it. Okay, this is where it gets good, Your Honor, and I brought this all to Mr. Gurmuti's attention. The uniform law citation that was filed to go with the complaint, right here, case number, says nothing about second degree homicide. In fact, the one that says second degree homicide was filed on 11/4, 6 days after the defendant was dead, 4 days after I was arraigned, by Sloan Kowalewski, stating that I committed second degree homicide on 10/27 at 12 o'clock p.m. It also says that I was arrested on a warrant on 10/30, 2023. Warrants were issued until 11/1. That's false. That's lies in the uniform law citation. Now, this is where it gets good, Your Honor. It says right here, do not write.
I'm not gonna, this isn't I'm not making any decisions on that. I'm not gonna dismiss your case today.
I'm not saying you are, but I need this
You're
all
going
on
into
record.
argument here on underlying issues. We're just dealing with the lawyer thing. So you think he should have filed motions on these things?
These are issues that I have brought to Mr. Gurmuti's attention, and he's failed to file any motions that I've requested. And I want it on record that these are the issues that I've requested the motions to be filed on.
Okay.
You know, these are major issues, Your Honor. They are. This is a murder case. There should be no topographical errors. There should be no misprints. There should be no false statements in felony complaints. There should be no false statements in warrants. Returns and tabulations should all be filed.
Well, I don't know whether they're false or not. I don't know whether they're wrong or not. And I don't know whether that would make any difference. So, again, what we're here on today is the attorney.
So basically what
You're
I'm
asking for different.
Basically, there's been breakdown in attorney-client relationship. Mr. Gurmuti has filed a motion to withdraw. I filed a motion for substitution of counsel based on, and this is just a few of them, just a few of the things.
Yeah,
You
okay.
know?
All right, I understand what you're saying.
You know, just, I don't know what to do, Your Honor. I'm looking at life in prison.
Well,
and I got a counsel that refuses to file motions.
Well, here's the thing, okay, and I'm gonna talk to Mr. Thompson, but one of the concerns I have is it's not gonna matter what attorney I appoint to you, because you're gonna find something wrong with any attorney that's appointed to you.
No, no.
Well, because you think that certain things have some significance, and if your lawyer tells you legally you don't have an argument here, or legally these are mistakes, but they don't affect the validity of the charges, you don't agree with that, and so you're gonna be back here again with your next lawyer who refuses to file motions that the lawyer thinks aren't warranted, and you're gonna be telling me the same thing. You understand what I'm saying?
Yeah,
Like
but
you don't want to hear what your lawyer's saying because you disagree with it, and so you want me to keep appointing lawyers until you get one that agrees with you.
Well,
and that's not how this works. So that's my concern.
Right, no, but
when I listen to you talking, that's my concern is I could appoint 10 lawyers for you, and until one does what you want them to do, you're going to claim that they're not representing you effectively.
See, this is the
Because
thing.
you're not listening to what the lawyers are saying.
Mr. Gurmuti doesn't even come and see me, Your Honor.
Okay, well, that's a different issue.
But this is the thing though, is the motions, Mr. Gurmuti or whoever is appointed should be willing to file motions on these things.
Well, but that's
And
not
it's up
true,
to you to
though.
rule on them, Your Honor.
Lawyers don't just file everything that their client wants them to file. They have an obligation under the law to only file things that have legal merit. So
And
if you want him to file something, and in his judgment as an attorney, he doesn't think that it has legal merit, he or any other attorney that I appoint for you isn't going to file it. And what I'm hearing you tell me is that you want an attorney that's gonna do everything that you wanna do.
No.
That's not how it works. So that's my concern going forward with you and appointed counsel, is that, again, I could go through attorney after attorney after attorney, and we never make it to trial because you can't find one that's gonna argue things for you that no attorney thinks has legal merit. So I'm just saying that for the record, that's my concern here. I do want to clear up some things that you said about the succession of attorneys and how we started and where we got. And Mr. Thompson.
Could I clarify before Mr.
Yes, Your
Thompson
Honor.
chimes in? Because I can just add a couple of things that Mr. Galt indicated. I think that's important for the record. So Mr. Seeger, I don't know the conversations Mr. Galt and Mr. Seeger had. But when I was.
Well, and I don't want to have you and Mr. Thompson, he's the administrator. He should, I want to hear what Mr. Thompson says. I'll give you a chance,
Okay.
Mr. Goodrich.
Thank you.
But I want to hear what Mr. Thompson has to say is going to clear this up or shed some light. So Mr. Thompson, can you tell me what information you have as the administrator of MIDC here?
Yes, Mr. Seeger contacted me. He indicated he was recusing himself from administering this case as well as being an attorney. I appointed Mr. Garamuthi, the court clerk. We've called and confirmed this with the court clerk. Made a typo on the P number, and that's how a lady named Miss Sullivan was identified on a court filing. But Mr. Garamuthi was appointed as attorney. Mr. Galt did request a new attorney through me. I turned him down. At one point, he did appeal. We had that administratively sent to Mr. Slough, the Otsego County Administrator, who issued a written decision also declining to appoint new counsel.
Okay, all right, thank you. Mr. Goodrich.
And that is where I was just getting at, Judge. So I don't know the conversations Mr. Galt and Mr. Seeger had. Mr. Seeger reached out to me about this matter as conflict for Kalkaska County. In those conversations, and Mr. Seeger may have had those conversations with Mr. Thompson previously or subsequently, I don't know. But one of the discussions was that since Mr. Seeger at the time was grieved by Mr. Galt, it made sense to not have Mr. Seeger on this case only administer the Kalkaska County MIDC administrative duties, and that should go to somebody else. And Mr. Thompson, being the Crawford County Administrator, only took over on this case to administer this matter. Whatever requests and funding or other things that we've had have gone through Mr. Thompson. At one point, I did reach out to Mr. Thompson with Mr. Galt's request for new counsel, because as Mr. Galt indicated, some of the motions that he wanted me to file, I think were frivolous. They weren't with what the law would require. And again, there was, when Mr. Galt indicates that a motion to quash was not filed, the court heard arguments that was filed. When Mr. Galt says that motions that he wanted were not filed, we did challenge the search warrant and filed motions to suppress evidence. Those were heard. We had arguments here in court. So I think Mr. Galt is incorrect that no motions were filed. The motions that he wants, that I don't believe legally would have any authority to be filed, were not filed because they're not there. For example, Mr. Galt wants me to file a motion to discredit Detective Nichols. I think that gets done at trial. There's no motion to discredit him prior to a trial. So again, the transcripts that Mr. Galt is requesting, he has those, because he has the preliminary exam transcripts. We had a full day, 8-hour preliminary exam in this court, and Mr. Galt was present. So again, some of the things that Mr. Galt indicates are not chronologically accurate. I did not know that there was that appeal process that went to Mr. Slough. I know Mr. Slough at some point did get involved because I received a subsequent letter from Mr. Slough because Mr. Galt had indicated that he wanted new counsel. I didn't know how Mr. Slough got involved, but I spoke with Mr. Slough. And I indicated where my concerns were, but my breakdown comes in after all of those things were done. Because suddenly Mr. Gall didn't get what he wanted. He didn't get a new counsel. He was turned down by 2 administrators. And I haven't met Mr. Gall in the last 2 weeks, maybe 3 weeks, because I'm not going to take his verbal abuse. I'm not going to sit there and get called derogatory names. I'm not going to deal with his threats. And if I'm going to spend my time meeting with him, it's got to be a productive meeting, not one where I get yelled at, screamed at, called names and threats being made.
Your Honor.
So at this point.
Second, I'll give you a chance. It's his turn. I listen to you. Go ahead.
So when those things happen, I'm not going to waste time and get treated that way. I'm not going to subject myself to that. Mr. Galt is, and I've told this to him, he's not my friend. He's not a family member. He's not a relative. And I'm under no obligation to take his verbal abuse because he doesn't get things done the way he wants or wants, new counsel, whatever his beef is. At one point, he was upset regarding something that happened with his house in landlord-tenant court. Again, there's a limit for me being a punching bag. I've got to deal with this case. This is where I am. But when it gets over that line, I'm not going to deal with Mr. Galt's abuse that way. I'm not going to subject myself to that. I have some self-worth. I'm going to hold myself to that. I've told Mr. Gall that, and Mr. Gall doesn't like that because I stand up to him. Leaving all of those things aside, Mr. Galt has filed a grievance. Mr. Galt has, my understanding, filed a grievance against Mr. Slough and Mr. Thompson.
Never filed one on Mr. Slough.
Mr. Galt's indicated he's filed a grievance against Mr. Ziegler. So in the middle of a murder trial and prepping, I have to deal with grievances that have strict time constraints and requirements and turning over documents and other things that come with the own separate proceedings that I believe are frivolous, but I have to deal with those. And I've just reached a point where I've had a breakdown with Mr. Galt. And then I can't do my duty. My loyalty to Mr. Galt is just diminishing because of his actions, his conducts. It's not something that I've done or I've not done for him. I've got kites from Mr. Galt that he indicates he doesn't have discovery. He's got 2 sets of discoveries, 10,000 pages or so of copies that have been made and provided to him. So when he says he doesn't have those, they're untrue. And I just can't do these things and then get into a position where I have to deal with grievances and malpractice suits when those are again frivolous that he's claiming that he's filed and he's done those things. So I've reached a point where there's a breakdown. I will admit to the court, the only thing that Mr. Galt does not have is the search warrant body cams because I got them this morning from Mr. Ziegler. They're in my pocket. And again, certainly my intent is to download them to my office drive so I have a copy. There's a laptop at the jail and then Mr. Galt will have a copy to watch those there. So that's the only thing that he doesn't have, but he doesn't have those because we didn't have them until this morning when Mr. Ziegler handed them to me in court. Outside of that, I've had numerous emails with Mr. Ziegler, numerous phone calls. We've talked about a lot of other issues, litigating issues. At one point, Mr. Galt wanted me to set up some interview with the FBI. And in fact, made threats because I was not doing that, made threats towards me for not setting up the interview. And again, I indicated to Mr. Galt, I need to know what you're going to tell the FBI because you have certain rights. If you're going to incriminate yourself, I have to advise you and warn you of those rights. He wouldn't tell me. We did set up the interview. The interview was recorded. And again, Mr. Galt, that interview never went anywhere because Mr. Galt got angry and upset because it was being recorded. The FBI agent did Mirandize Mr. Galt, and that's not how Mr. Galt wanted to operate. So all of the things that Mr. Galt has done has, at least for me as an attorney at this point, led to a breakdown where I can't communicate with him. I can't represent his interest, and I refuse to go forward with this case and assist Mr. Galt any further because of what he's done with his verbal abuse, his threats, his derogatory attitude towards me, and I'm just refusing to put up with that, Judge.
All right, Mr. Ziegler, people take any position?
Your Honor, normally I would leave this kind of thing to the court and to the attorneys, but in this case, this is a case that has been going on for quite some time. Obviously, it's a very serious case. It's a case I would like to get to trial as quickly as possible. I agree with the court's concerns regarding Mr. Galt's behavior. I think it doesn't matter how many attorneys you appoint, and that's evident from the fact that Mr. Seeger had to withdraw, and Mr. Galt briefed him. Now Mr. Gurmurthy is asking to withdraw, and apparently Mr. Galt is grieving him. I have no doubt that if you appoint a new attorney to represent Mr. Galt, that attorney will ask to withdraw. Mr. Galt will grieve him, and we can play this game for however long as Mr. Galt wants to play it, or however long as the court wants to entertain it. But at the end of the day, we're going to have a trial on this case. There's no likelihood of any sort of plea resolution. We have a trial set in May. I would prefer to have that trial as opposed to appoint a new attorney, kick the case out 6 months, and then come back here in 6 months on probably similar issues where that attorney is not going to want to file frivolous motions. And Mr. Galt wants that attorney to file. So for those reasons, Your Honor, I don't think the court has to permit Mr. Gurmurthy to withdraw. I'm certainly sympathetic to Mr. Gurmurthy's position here today. I think he had to do what he had to do. He had to file this motion. He had to make his conflicts known to the court. I certainly wouldn't want to be in his position today, Your Honor, but from my perspective, I have a duty to the victims to bring this case to a trial and to a resolution as quickly as possible, and I would oppose any further delays.
Mr. Galt, anything else that you want?
Your Honor, I've never verbally abused Mr. Gurmurthy. You know, we've had conflicts. Yes, we have. We've argued. Yes, we have. But the things that I've asked Mr. Gurmurthy to file motions on are legitimate things. The fact that I never even got a copy of the motions that he filed is legitimate. You know, Your Honor, you're the one that told him this is unacceptable. You didn't show up to court. This is unacceptable. You did not file your motions on time. That was 14 months. Mr. Seeger killed 5 months before he was willing to withdraw because of the conflict issue. I didn't grieve Mr. Seeger for another 6 months after that. So it's not why, the grievance is not why it got handed over to Mr. Thompson. The grievance didn't come for months, 6 months after Mr. Gurmurthy was assigned the case. Okay, I mean, I got a search warrant right here that was never signed by a prosecuting official, by a non-attorney magistrate. You know, Mr. Gurmurthy fails to be willing to file a motion on these things. Your Honor, you said in court last time we were here that you're not going to have this come back on an appeal. Your own words, Your Honor. So these things are things that are going to make this come back on an appeal. Mr. Gurmurthy just got a copy of the body cam footage of the search today. 18 months, Your Honor. And he just got it today. I've been requesting it the whole time. I've been requesting officer activity logs the whole time pertaining to the deactivation of body cam footage. I've researched case laws. I mean, all these things are legitimate motions that should be filed, Your Honor, and you, Your Honor, get to rule on them whether they're frivolous or not. That is your job. These are legitimate things that counsel should be filing motions on as a defense counsel. He works for the state. You know he works for the state. He don't work for me. You know, he's told me several times, I got funding for this, I got funding for that, I got funding for the transcript. I contacted Nicole Hagstrom, the transcriber. She said, I contacted Mr. Gurmurthy. He said he'd do what he has to do on his end. We'll get you them transcripts. Nothing. I got a paper right here signed from Mr. Paul Stout. Said that only appointment of substitution of counsel is warranted only by showing of good cause. Good cause may exist when there's a legitimate difference.
I understand that. I don't need you to read that to me. I know what the standard is.
And it stands right here, Paul Stout. Mr. Gurmurthy's filed a motion, said there's been a breakdown in the client, destruction of communication and breakdown in the current attorney-client relationship. I filed several motions. There's been a breakdown in attorney-client relationship beyond repair. Beyond repair. If you send me to trial with Mr. Gurmurthy, Your Honor, that's automatic grounds for appeal. You said yourself, you don't want this case to come back on an appeal, and I'm quoting your words over and over again. If you don't want it to come back on an appeal, sign me a counsel that's going to file these legitimate motions.
Okay. All right, you're just starting to say the same things over and over again.
You know, I'm not trying to
Okay.
waste
All
the
right.
court's time. I just want proper representation.
Okay, I understand.
And then, I'm sorry, and the typo, Mr. Thompson says typo. Your Honor, this is a murder case. There should be not typos. The T should be crossed, the I should be dotted. There should not be wrong dates, wrong addresses, none of it. This is a murder case, Mr. Ziegler. It's a murder case. This stuff should all be checked and double checked and triple checked and quadruple checked before it is even filed. The notice right here, let me show you this, Your Honor, before we end this. Right here, Mr. Gurmut's withdrawal is dated December 9th. December 9th, dating a, where is it? I got it right here, Your Honor. I'll pull it out of this one. The notice for hearing for today dated December 9th, 2024, for an April 8th, 2025 court date. That's 4 months ago. This paper right here is grounds for an appeal. You know, Mr. Seeger, 150 days. Here's another 4 months. Mr. Guramuthi didn't represent me. That's 9 months out of the 18, Your Honor. My 180-day rule was violated. My right to a speedy trial was violated just because of these issues. Mr. Ziegler in his motions are quoting COVID-19 case laws for violating my 180-day rule and my right to a speedy trial. You read the motions, Your Honor. I've actually got them right here if you want to go through them again. His motions are quoting COVID-19 case laws for violating my 180-day rule and my right to a speedy trial. There's grounds for appeal. Any case is prolonged for more than 18 months. The people's got to answer for it. By the time I go to court in May, it's going to be 19 months. That's automatic grounds for an appeal. The people are going to have to answer why I wasn't in trial before 18 months.
Okay.
You know what I mean? I mean, I'm trying to save the court's time, Your Honor. I just want
I
proper
appreciate that.
representation.
Yeah, okay, all right. First of all, with regard to allowing counsel to withdraw or appointing new counsel, this matters within the discretion of the court. I'm acting within my discretion of ruling on this. First thing I would say, Mr. Galt, is you're free to hire your own attorney at any time that you want. Nobody's forcing you to have court-appointed counsel. So you're free to hire your own attorney. To the extent that you're asking the court to appoint counsel at public expense, there's a process for that. And that process has been followed. And it's resulted in Mr. Gurmurthy being appointed as your attorney. The fact that you filed grievances against him or other attorneys isn't a reason for the court to appoint new counsel. It's not a reason for the court to allow counsel to withdraw. That's been through case law clearly established that defendants are not allowed to delay cases or shop for new attorneys by filing grievances in the hopes of having that attorney disqualified or somehow being required to withdraw. So the grievances aren't a reason. MIDC has addressed your request for new counsel. Under the law, it's clear that the court is to be minimally involved, if at all, in that process. This is the last step, which is the only reason why it's before me, but it's clear that the legislature has determined that the best process is for the court not to be involved because the court's supposed to be impartial and shouldn't be involved in issues relating to your counsel. So this is only here as a last resort, but MIDC has followed their policy and procedures and they've denied you from receiving new counsel. So the MIDC, through two different administrators, have determined that there isn't good cause for you to be appointed new counsel. I have concerns, as I articulated before, and listening to you, but it just reinforces those concerns that it doesn't matter who's appointed to you as your counsel. I'm convinced that you're undertaking a course of conduct here to create appealable issues on your own, and you've admitted it. You're on the record. you told me that you purposely didn't say anything about paperwork that you received and let counsel go forward in the hopes that that's going to create an appealable issue. So I think you're actively, and I want the record to reflect that I think you're actively trying to do things here as part of the pretrial process in hopes of creating appealable issues so that if you are eventually convicted, you'll have a basis to come back. And I think that's important because to the extent that I would find good cause to appoint you different counsel or to have Mr. Gurmurthy withdraw, I think you continue along the same course of conduct with the new attorney. Not only to delay as long as you could in the hopes of getting to the 180-day issue or whatever you perceive to be as issues that could result in a reversal of your conviction later, including delay, including complaining about your counsel, including doing things in your interactions with your counsel. All of that, I'm convinced, is a deliberate course of conduct on your part aimed at creating appealable issues. And I'm not going to allow you to just continue to do that over and over. I think there is not cause here to appoint new counsel because, again, I think the same issue would simply come up over and over again. We did have hearings on the motions that Mr. Gurmurthy felt had legal merit. I agreed that they had legal merit, and I made rulings on those issues, a lot of which involved issues that you're raising here today about affidavits and signatures and those types of things that the court has addressed.
But how
And
about,
not every mistake, not every typo means that the court has to throw out an entire case against you. So the fact that there are errors, there are minute typographical errors in every case, I would argue. But that doesn't mean that you're just entitled to dismissal of charges because an I didn't get dotted or a T didn't get crossed. So to the extent that you think that's an appealable issue or a reason for your counsel to file a motion to dismiss murder charges against you, which are very serious, I just think you're wrong about that.
I'm not saying that.
You did say that. And I'm not going to debate. Yeah, I listened to you. I was very quiet. I let you say everything that you wanted to say. Now it's my turn. If you're going to keep interrupting me,
Sorry.
I'm going to have you removed from the courtroom and I'm going to continue to make my record. Again, I don't think there's good cause because I don't think this is a legitimate disagreement between you and counsel. I don't think I don't think you're raising legitimate points. I think this is, again, a strategy on your part to try to delay the trial, to create an appealable issue in and of itself, or to create problems with counsel, to create appealable issues. And I'm convinced that, again, to the extent that I would appoint new counsel, we'd be back here in 3 months with the exact same issues. I think Mr. Gurmurthy filed motions on the things that he felt had arguable legal merit. The court made rulings on those motions. So the court is going to deny your request for appointment of new counsel. In terms of Mr. Gurmurthy, your motion to withdraw, I agree with Mr. Ziegler's sentiments that you're not in an enviable position. It's a difficult position to be in. I agree that you don't have to put up with abuse. Mr. Galt, to the extent that you're going to argue with, verbally abuse your lawyer, you're only hurting your own case. And so I would suggest to you, you've got a trial date coming up in May. I would suggest to you that it's in your own best interest to start cooperating with Mr. Gurmurthy and start working with him instead of working against him. But that's up to you. You're going to make that decision. We're going to go forward with trial in May as scheduled. Mr. Gurmurthy, the court's denying your motion to withdraw for the same reasons that I'm not allowing new appointed counsel. And the only thing I would say, Mr. Gurmurthy, is to the extent that Mr. Galt doesn't want to cooperate with you, to the extent that he engages in abusive verbally conduct with you, arguing with you, he's only doing that at his own risk. And again, I'm sorry that you're in that position, but I think that's where we're at. So, and Mr. Galt falls in your court as to whether you want to work with your attorney. But we're going to proceed with trial as scheduled in May. And Mr. Gurmurthy, I just request that you prepare an order that reflects the court's ruling today. Submit that under the 7-day rule.
I was just gonna send it to Mr. Ziegler for approval and we'll submit it. Normally, we're good with community members. So we just do that.
That's fine.
Your Honor,
Yep.
does it matter that this was never, his appointment was never consented by me and never ordered by a judge?
I guess that's something you could bring up on appeal if you're.
Okay, and the fact that Mr. Guramuthi has admitted that there's attorney-client breakdown beyond repair?
I don't know that he's done that.
He did, it's in his motion.
That's again, you want to create appealable issues, so you can bring them up on appeal if you're convicted.
Okay.
Thank you.
That also includes the court's afternoon, court will be recessed until 1:30.